The right to fair trial is recognized by the international community as a fundamental human right necessary in any democratic society governed by the rule of law. Various international instruments, such as the Universal Declaration of Human Rights, the International Covenants on Civil and Political Rights, as well as regional instruments, including the African Charter on Human and People's Rights, have enshrined these rights. According to Article 7 of the African Charter, in order to ensure the respect of the right to fair trial, several other trials or rights have to be guaranteed. They are intrinsic elements of the right to a fair trial. The focus will be on one of these rights. However, I want to consider on Law and You this week the right to a counsel. The African Commission on Human and People's Rights and the African Court on Human and People's Rights had likewise the opportunity to respond to complaints apropos of the right to counsel. Both bodies have strived to ensure the respect of these essential rights. From their jurisprudence, it is therefore possible to identify general standards which can be used to complete the international and regional legislation applicable on the matter. This jurisprudence analysis will focus on the three major violations on the right to counsel: lack of access to counsel, delayed access to counsel, and restricted access to counsel. Hello and welcome to Law and You on ITV, coming to you from Benin City, Nigeria. I am Uyi Agmofwegbe. Law and You begins right now. Thank you for staying with us on the program. My guest today is an experienced lawyer who will help us beat this conversation on the program into context. Matthias Obayiwana Esquire, thank you for coming on the program. We appreciate it. Thank you, Uyi. All right. You and I have spent time again and again to talk about law and rights in particular of citizens. But today I want us to pay more attention precisely to access to a lawyer, because it's near impossible to talk about issues of law and not mention the place of lawyers or counsel in the middle of that conversation. But when you look at our environment, it will appear we are not very informed about many of these things. Walk me through the issue about access to a counsel.
Well, access to a counsel are in different categories. Mm-hmm. You need access to a counsel in your private dealings. For example, you want to enter into any negotiation, mm-hmm. to any transaction, you require the advice of a counsel as to how to go about it and what to do. Yeah. To safeguard your investment. That's a private right. You have a public right, or a constitutional right to a counsel, where you are accused of having committed any offense in any wise. The law guarantees you a fundamental right given to that individual to a counsel. Whereas the private, as far as the private right is concerned, you may decide to do without a counsel if you desire not to. Mm. But for the public right, constitutional right, it's a fundamental right owed you. So by any public institution, who may be engaged in investigation of any alleged crime in such a way that they cannot deny you that right to a counsel. You find a situation where people are accused of committing offense, charged for any offense before any police station, police officer investigated the matter, and they deny the the right to even consult with their counsel. So this right, under the Constitution, like I said, it's a fundamental right. They are enshrined in two sections of the Constitution, Section 35 and Section 36. 35 have to do with the liberty of persons, and 36 have to do with fair hearing. For the avoidance of doubt, I want to read those provisions so that the general public will be made aware of this fundamental right which they enjoy under the law. See,
obviously, that's a copy of the Constitution.
Yeah, it's a copy of the Constitution. I want to encourage every Nigerian, at least from Section 33 to 46 of the Constitution, that deals with the fundamental rights of citizens. It's important for every Nigerian to know your rights. Read through those provisions, you see the safeguard the law has placed to ensure that you enjoy your right. Now we look at Section 35 of the Constitution that deals with liberty. Right. 35(2) we are looking at now. Say every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty, save in the following cases and in accordance with the procedure permitted by law. Now, those cases were listed. Now, the right to a counsel, 35(2). Any person who is arrested or detained shall have the right to remain silent or avoid answering any questions until after consultation with a legal practitioner or any other person of his own choice. So you have the right to a counsel to consult with your legal practitioner before you can even answer any question put to you by any police officer in the course of the investigation. So that right cannot be denied any person accused of committing any offense. Now we go to section 36, which has to do with the right to fair hearing. Section 36(6) sub C provides that every person who is charged with a criminal offense shall be entitled to defend himself in person or by legal practitioners of his own choice.
Of his own choice.
Of his own choice. So this is the right to a counsel even at the stage of police investigation, and after the matter be charged to court, you still enjoy the right to a counsel of your choice. You know, so these rights are very fundamental. They are then fundamental laws, and they are actually in sections for fundamental rights. They are rights that are inalienable and that cannot be denied, you know, of Nigerians. Now, to trickle it down, recently a law was passed by the Edo State House of Assembly, you know, the Administration of Criminal Justice Law of Edo State. That same law, which was domesticated from the ACJA,
right,
Administration of Criminal Justice Act, we are domesticated in Edo State in section 6 of the same law. You know, provisions were also made as to the same right which the Constitution has provided, the right to a counsel. Section 6, I will read. Except when the suspect is in actual cause of the commission of an offense or is pursued immediately after the commission of an offense or has escaped from lawful custody, police officer or other persons making the arrest shall inform the suspect immediately of the arrest, immediately of the reason for the arrest.
Okay.
The police officer or the person making the arrest or the police officer in charge of a police station shall inform the suspect of his rights to A. Remain silent or avoid answering any question until after consultation with a legal practitioner or any other person of his choice. B. Consult a legal practitioner of his choice before making, endorsing or writing any statement or answering any question put to him after the arrest. And C. Free legal representation by the Legal Aid Council or any other institution offering like services in Nigeria where applicable. You know, the authority having custody of the suspect shall have the responsibility of notifying the next of kin of the suspect arrested at no cost to the suspect, provided that where the suspect refuses to disclose the name or address of other persons of reaching his next of kin or relative, the authority having custody of him shall be discharged from this responsibility. What does the law say? When you refer an arrest on anyone,
yes, they
have the responsibility to notify his relations. We have your person here with us. They have that duty to. It's not that they seize the phone from them, they keep them in silence. The relations are looking for them, they don't know where they are. The ACJA say no. The officer arresting must notify what he has done, must, you know, let him know his right to his counsel to consult with his lawyer before answering any question or making any statement, and also notify his relation as to his whereabouts. This is what the law says. Now I will go a little further, you know, to look at section 17, which provides for when statements is being taken out from the suspect. This is what the ACJ...
And that's a critical part of the investigation process.
Exactly. This is what the ACJ had to say. He said, where a suspect is arrested on allegation of having committed an offense, his statement shall be taken if he so wishes to make a statement. If you observe, we are saying in the Constitution, you have the right to remain silent.
That's a conditional clause. If
he desires. But you find a case whereby they force them to make a statement, they beat them, they compel them, they harass them. This man or whoever it is has the right to remain silent or not to speak to you until he consults with his lawyer. So look what the SCJ says. Now we go further. It says such statement may, where the suspect so elects, be taken in the presence of a legal practitioner of his choice, or where he has no legal practitioner of his choice, in the presence of an officer of the Legal Aid Council of Nigeria, or an officer of a civil society organization, or a justice of the peace, or any other person of his choice, provided that the legal practitioner or any other person mentioned in this association shall not interfere with the suspect when the suspect is making a statement. You know, and then went on to say that it shall be the responsibility of the officer recording the statement of the arrested suspect to bring to his notice his rights under the foregoing subsection. But it shall be the responsibility of the suspect to elect and decide on his legal practitioner or such other person to witness the recording of the statement. Now we have seen what the law says from the Constitution to the ACJA of the rights which the individual enjoys. The right to a counsel is a fundamental right recognized by law, by the Constitution, recognized by the ACJA, the Administration of Criminal Justice Law, in such a way that suspects are not treated as criminals. Because under the law, Section 36(5) of the Constitution, every person accused of commission of any criminal offense are presumed innocent until the contrary is proved. So if you are accused of any offense and the presumption of innocence you already enjoy, it therefore behoves on the authority, you know, limiting your liberty to let you know of your rights under the law, to even remain silent, or with, you know, until you consult with your lawyer and all of that. But the opposite is the case as we speak. In a society today, you find officers arresting anyone, detaining them without informing their relation, seizing their phones, you know, in fact, even driving their relations. So lawyers, you know, who may also not even be informed, to inform. Because some lawyers are even aroused when they go to the police station. You see police say, go and wait for us in court. This is not the court of law. No. The lawyer has a right to represent his counsel, to be with him, to represent his client, to be with him when his client is writing his statement. To tell a lawyer to say, don't leave this place. Don't take the statement of your client. Go and wait for us outside, or you can wait for us in court. No. The law is very express on this. So the officers, you know, I should believe that some of them are undergoing training, and they actually know the position of the law on these issues, that every suspect will be treated with respect. Dignity of a human person must not be violated because he's presumed innocent. And then when you are interrogating him or taking a statement from him, he has a right to have his counsel present, or any person of his church to be present with him, to ensure that he's not being coerced into making any statement to the police.
A lot of persons believe that there's a level of strife, as it were, between the police and lawyers. That's why we have these unpleasant dichotomy.
Yes, for most police officers who are not informed, many of them, you know, believe it's an ego problem. Okay. When they see a lawyer in the police station, they feel harassed. And then the general cliche, go and wait for us in court. This is not a court of law. Criminal investigation or prosecution begins from the point of arrest, when you limit the liberty of another person. From that point onward, that suspect has a right to be afforded the facilities, all facilities, you know, necessary to enable him defend himself, which include the right to a counsel. This brings us to this case. This is the case of COP and Okoye. The Supreme Court has pronounced that where any person is charged, you know, for any offense whatsoever, that person is allowed access to all the necessary facilities he requires to defend himself, including the petition written against him by, you know, whoever the complainant was, including the investigative report, if anything has been done, whatever I think that the police are done in the process, they must, you know, make them available to the suspect to enable him to defend himself. I will read quickly, you know, the provision of the law. This is what the Supreme Court had to say in the case of Okoye and COP for this same issue. On meaning of facilities and facilities that must be afforded an accused person to defend himself. He said the word facilities is not defined in the Constitution. However, facilities is that which promotes the ease of any action, operation, transaction, or course of conduct. The word facilities embraces anything which aids or makes easier the performance of the activities involved in the business of a person or corporation. The facilities that must be accorded an accused person by virtue of Section 36(6)(b) of the Constitution as amended are the resources or anything which would aid the accused person in preparing a defense to the crime with which is charged. These no doubt include the statement of witnesses interviewed by the police in the course of the investigation, which might have absolved the accused of any blame, or which may assist the accused to subpoena such favorable witnesses that the prosecution witnesses may not want to put forward to testify. Right. So in everything that the police officers have done in the course of their investigation, statement taken from a complainant and all of that, the accused person or the suspect coming from the police station has a right to demand for them. I want to know what case you have against me. I want to see the statement of the witnesses against me. I want to see the evidence that you have against me on this issue, so that I can have an informed position in defending myself. Most often than not, Nigerians are not aware of their rights because they don't read. That's why I've taken the pains to read the law. So let's know the thing that I'm
to set the record straight.
Exactly. That the lawyer is speaking to the law, or speaking his own opinion. No. Everything I've said here today are in the code letters of the law. So every Nigerian should be aware of their rights under the law. So when the lawyer comes to the police station, the lawyer is supposed to guide the suspect as to his rights. Even though the police officers are, obligated under the law to inform the suspect of their rights, but often they don't do so. So the lawyers come in, to fill in the gap, to insist that, look, my client has some right to enjoy here. You cannot treat him in this wise. You cannot treat him in that wise. So these officers, they do not want, they are lazy persons, with all due respect to some of them, not all of them. So they cannot think outside of the box. So when they have any allegation against a particular suspect, they want to beat the suspect to get confessions from him. Rather than confronting him with facts, they are investigating outside of him in such a way that he can either deny or refuse, or admit them. They are too lazy to go and do such investigation. They want to, receive the suspect, harass him, intimidate him, get him to confess to whatever he has not done. We have seen instances, I've done some matters, instances where a police officer from state CID, used cutlass to tear open the palm of a suspect, trying to get him to confess to offense of armed robbery. Must you do so? So if you have evidence outside of it, think outside of the box, outside of this suspect, you confront him with it. This suspect has a right to remain silent. The law is clear already too. If the witness said, the suspect said, I will not say anything, the law expects that officers should have done the investigation outside of him, sufficient enough to nail him.
To be able to get facts.
Exactly. Rather than to insist that you must make statement to me. And even when they are even making statements, saying, sir, I'm innocent. They are beating them, forcing them, hanging them, torturing them to do all that. The law is aware of all of this. That's why enactments have been made to curb it. In curbing it, they insist that the lawyer should be present when they are making statement or any relation of theirs in such a way that it will be safe to assume that they were not coerced or dehumanized or terrorized to make such statement.
Okay.
So that's the position. So the right to legal petitioner is a fundamental right for persons accused of committing.
Well, we're going to take a quick break at this point. Barrister Matthias Baiwana will talk a bit more about this very topical issue regarding access, or if you will, right to an attorney. We're back shortly. Stay with us. Thank you for staying with us on Law and You. Let me just talk to you a bit more about, as some people will say, lawyers in particular will say, when police officers behave in the manner that you have painted, I mean, some of them do behave that way, they would have acted ultra vires, apparently. But how do citizens, members of the public, seek redress in instances like this?
You see, it's often said that when the act of an abuser is condoned, the abuser is encouraged to continue the abuse.
Right.
A police officer, whoever it is, in the course of investigation, slaps a suspect, dehumanizes him, asks to sit down on the floor, does anything to him to reduce him and make him less human. Take note of that officer, because the law does not, it is not part of his own constitutional duty. The police had a duty, that's section 4 there about the Police Act, to investigate crime and prosecute. So investigation does not include dehumanizing any person. Even prisoners have rights.
As prisoners?
Yes, prisoners have rights. Those who are even be convicted, they have rights. Because they must be fed while they are in prison. You must not dehumanize them even while they are there, when they are serving their sentence. Except maybe the law says use care to beat them, send them to hard labor. Whatever the law says must be done. Even when you say, kill somebody by hanging, and you now tie the person to a stake and use firing squad against that person, you have violated the law. The law says, execute this person by hanging and not by shooting. So you must act according to the law. So prisoners even have their own rights. No talk of persons who are presumed innocent. So when any police officer does such a thing to any Nigerian, take note of that officer and bring an action against that person to enforce fundamental human rights against him, no matter how slight that demonization will be. No matter how you know how short the period of confinement might be. Because we have found even cases where issues are not to do with the criminality, maybe civil contract.
Yes.
Then the police officer will come into the matter because he knows the complainant and begin to harass individuals and say, well, you took money for so person. Yes, we have a contract together, and I took money from him. If I couldn't fulfill it, my own terms of the bargain, actually could be brought against me for breach of contract. But not to say because I could not fulfill my own terms of the bargain under that contract, then they will usually say, oh, 419. Receiving by false pretense, obtaining by false pretense. So for that reason, they want to hide under that guise and begin to harass persons over an issue of contract. The law has come out very clearly that any contractual transaction cannot in any way ripen into element of criminality. So you see them doing such things. So when they have done with all of this, take your time, take note of the officers. If the authority in question, maybe the commissioner of police, which their guard at the top, is supporting the officers in doing that, take note of all of them. Bring an action against them for violating fundamental human rights. When you do that, claim damages, I'm sure the law court, given the position of the law, fundamental rights, we support them. The law court will begin to come out with judgments against such individuals. Then when Mr. A hears of a judgment against Mr. B for such an offense, that Mr. A will not try such nonsense next time, because knowing that person may not take it lightly. But by the time you are done, see, what do we do? After all, we are out now. They have finally paid us now. We should just forget. There's no need to pursue this matter. Tomorrow, that officer will do it to another person.
So somebody has to set the precedent.
Exactly. So when your rights are abused in any way, even in the course of investigation by a police officer, bring an action against that officer. Because it is not part of the constitutional responsibility to demonize people's rights or demonize any person, violate people's rights in the course of investigation. They should be treated, with dignity. Under the law, you can interrogate, you can ask questions, but you must not demonize them in any way. How can a suspect be asked to sit on the floor when making statement? That is demonizing him. How can you begin to slap a suspect when he's taking statement? How can you shout at him and call him principal names, harassing, calling criminals, threatening him with a gun and cutlass when he's making his own statement? You are demonizing him.
There's the argument that there's pretty much of nastiness beyond the police now, generally within the law enforcement chain. How do we begin to clean up that process?
You see, people must be used, as scapegoats. When such things happen, more often than not, you report to the superior officers. I know the guys at the top are more civilized than those lower officers.
Some of them are even lawyers like yourself.
Yes, so when you report such cases to them, they are aware of the position of the law. Yes. I'm sure they will often call the officers, to order. Then, while there are some of them who also benefit because they get report or returns from the officers below. So when such things happen, instead of reprimanding the officer, it's okay, don't worry, they may quarrel with him in your presence, and nothing happens afterwards. So that is why, beyond reporting the officer to the guys at the top, the superior officers, bring an action against them. When court begin to turn out judgments against these erring officers and the establishment they belong to, they begin to learn that they don't behave that way. Good enough, under the ACJL, the magistrates and some judges are even empowered to go visiting some of these facilities, prison facilities or detention facilities, to find out how long these persons have been in their custody. They are supposed to send returns, to this body to ensure that people are not being demonized in any way. So when any person is demonized in such a way, you bring an action against them before the court of law. You are able to prove your case as to how you were demonized. Because there are two issues now. The first issue that they are accused of committing an offense. Fine. Right. Investigate that offense. If you find me culpable, charge me to court. But because of doing so, you end up violating my own rights, fundamental rights. I will bring an action against you for that. That's a different issue entirely. So nobody is saying that you don't have the right to investigate me. Right. You have such right. But the process of that investigation matters. It has to conform with the law. That is what it Thank you so much. We've been talking about access, or as we want to put it for the purpose of this discussion, right to our attorney. And I've been talking with Barrister Matthias Obayewana. Thank you for coming on the program. I appreciate it. Thank you so much, Ori. That's our program for this week. Enjoy the rest of your Monday. I'm Uyag Mofwegbe.